Deputy Speaker, members of this House, let me first express my appreciation. My appreciation for, first, our points of agreement. I believe all of us are agreed, and I'm looking at the leader of the opposition. I believe all of us are agreed that we are facing a global life and death crisis, which requires extraordinary measures. I believe all of us are agreed that contact tracing, effective, rapid contact tracing, is essential as part of our response to dealing with COVID-19. I also venture that all of us in this Parliament are agreed that TraceTogether and Safe Entry, representing our digital contact tracing tools, have made a real difference to the effectiveness of our COVID-19 response. And in particular, I would reiterate that it has enabled us to shorten the period from 4 days to 1.5 days. What I want to do now is to share my personal timeline through this journey. Let me begin. We first stated that the government would use TraceTogether data only for contact tracing, simply because this was how and why we designed TraceTogether. I can tell you all categorically, again as a doctor and as perhaps a techno-optimist, that the potential use of the data by the police did not cross my mind or the mind of my engineers at all. I state that categorically. And in fact, if you think about the features that we built in, encrypted, decentralized data, auto-purging after 25 days, encrypted identities, no GPS, no cellular connectivity. I think any fair-minded person with some appreciation of technology will know that what we had in mind was digital contact tracing. If we were not at all trying to create a surveillance tool. I say this so that you understand my state of mind when I said what I said in June. But what I said in June was wrong, because in a sense, my own enthusiasm for the technology blindsided me, and I did not read Section 20 of the CPC. Because the law of the land is that the CPC, specifically Section 20, does authorize police to access many databases, including contact tracing data. The next point is, when did I become aware that what I said was wrong? And basically what happened was at the end of October, I was asked, are you sure that the CPC doesn't apply, even for a murder case? A member of the public asked me. When I received that query, I asked my staff, please go and double check. I'm not a lawyer, but please go and double check what the legal provisions are. At that point, I was informed that the CPC applied, and that in fact the police had requested TraceTogether data on one previous occasion. Your next question should be, well, what did you do after that? And I'll tell you very frankly, in fact, I've shared last month, I had many sleepless nights, and I engaged in several rounds of discussion with some of my senior cabinet colleagues on whether we should carve out, and if we did, how should we carve out the contact tracing data from the application of the CPC. You will know that my own strongly held view at that point in time was that even if the CPC applied, and even if we were going to make data available, we should exercise this with utmost restraint. I was also aware that I had first made this assurance in this chamber. I think it was in June, in this chamber. And I told my staff, regardless of the outcome of this internal review, we will come back here and we will clarify. And we did that last month. Mr. Christopher D'Souza filed a question, I believe it was in early December, about a month after I commenced this process of internal discussion. I'm sharing this with you so that you understand that there is nothing to hide. The CPC is written law, but I should have been aware, and I should have made it clear right from the onset. You know, I've reflected that if in June I had added 4 words, subject to prevailing legislation, perhaps we wouldn't be here this afternoon. Nevertheless, it has occurred.
Questions for Minister. The first being Minister's revelation that he came to the knowledge that Section 20 of the CPC would apply from end October onwards. I'm just reviewing the articles in our newspaper of record, the Straits Times, from end October right through early November. A number of representations made by various ministers, but nothing suggested that the government was going to make the revelation that the minister shared in early January clear that Section 20 of the CPC would apply. And that actually came in October, a good 2 months later. Can I ask the minister what was the cabinet deliberating, if that was an issue with regard to the cabinet, or what caused the delay in coming to a landing on the time by when the government will make things clear to Singaporeans. The second question I have pertains to a figure that the Minister gave in his speech, 58%, and correct me if I'm wrong, Minister, because I may have misheard you, and I apologize for that. 58% turn on their TraceTogether at least once a day. I believe that's what Minister said. The question actually that I asked, and I think a few other members asked, was whether the government is able, Smart Nation Office or GovTech is able to track when people switch off their TraceTogether applications, because that really is the key. Because if for some reason people are not confident, then we've got a problem on our hands. So how is it that the government is able to track that people can track when people switch on their phones at least once a day, but for some reason is not able to find out when people turn on and turn off their phones?
I thank the leader of the opposition for his vote of confidence and his advertisement of his use of TraceTogether. Let me deal with the first 2 questions. So at the end of October, when I was asked, basically what did I spend November doing? As I said, double checking the legislation, and then having, among sleepless nights and conversations, do we carve it out? How do we do it? What should we do? So that occupied us in November. Mr. Christopher D'Souza filed, said in December, and I thought it was right that we should answer it in Parliament. If I could replay, actually if I could rewind time, I wouldn't even have made this mistake in June. And I would also say, if I could replay, I would also have looked for an earlier occasion to explain all this. But the key point which I'm trying to make is that there was never any doubt in my mind that we would clarify, that we would explain, and we would be held accountable, and that I would take responsibility. That's the way we operate. And for myself, having been in this chamber now for almost 20 years, the older members will know I have always operated that way. Mistake, what's, misunderstandings, misspeak. I have never shied away from clarifying it. So I am grateful to you. I think it was last month when you said you accept in good faith my explanation. So never any attempt to shy away from transparency and from reflecting the mistake. On your second question about why I said 58% switch it on at least once a day. Again, if you look at your ad, and if you see somewhere about the upper third, it will probably say you're okay. What it does in order to tell you whether you're okay or not is that it has to query a central server as to whether the safe entry check-ins that you have done have overlapped in time and space with someone else. If you have, then some of you may receive a slightly more worrying message to say that, this has happened. If you have symptoms, please see a doctor and please get tested. Now, of course, if we have identified you as a close contact on the basis of Bluetooth proximity data from TraceTogether, you don't need to wait for that message. We will call you and test you and isolate you if necessary. But anyway, to come back to the question of how come you know I'm on but I don't know when you're off. So I know you're on because you've actually queried the database to check whether your journeys overlap with someone else who may have been positive. But I don't know when you switch it off or when you, as Gerald Giam has mentioned, put it in a Faraday cage. I don't know that precisely because of the privacy-respecting design of the system. This also relates, although you haven't asked it, to the question about how useful is TraceTogether data for police investigations. And again, I would reiterate my explanation that by its very design, I was not designing a surveillance system. So you can make a reasonable argument that therefore, most times, it's not going to be very useful because it was never designed for that purpose. But the reason why I'm still coming to this House and still asking for this carve-out for the seven categories of serious offenses, it's really about a value statement, you see, to say that for these types of situations, you do not believe in tying the hands of your police force unnecessarily. And for those of you who have served in the police force, Ms. Sylvia Lim has, I believe, been a police officer. Mr. Murali has been a police officer. You will know DPM Heng has been a police officer. You will know that when you're investigating any leads, indirect, circumstantial, or otherwise, may be relevant. And even if you don't identify the suspect, it may help you identify a witness. So what we are saying in moving this bill is that at least for these 7 categories of serious crimes, let us agree not to tie the hands of our police force. And I'm grateful to you and to the Workers' Party for saying you support this bill.